My name is Mitchell Tsai. Myself and Christina Cara Ems, Broadswell, Joseph, and Cardozo are representing the Arroyo Seco Foundation and the Pasadena Audubon Society in their lawsuit against the County of Los Angeles to stop the Devil's Gate Dam sediment removal project, otherwise known as the Big Dig. I am very confident about the Arroyo Seco Foundation and Pasadena Audubon's chances of prevailing in this case due to the number and quality of issues that are being presented. The California Environmental Quality Act lawsuit filed by Pasadena Audubon and the Arroyo Seco Foundation has no trial date. The parties are currently simply preparing the evidence in anticipation of going to trial. There are three ongoing processes going on with the lawsuit. First, the lawsuit that has been filed under the California Environmental Quality Act challenging the approval of the county for the Big Dig project. However, there's also ongoing processes with permitting processes under the Federal Clean Water Act and the Federal and State Endangered Species Acts. The Seco Foundation and Pasadena Audubon Society are raising a number of issues in this lawsuit. But most importantly, the Arroyo Seco Foundation and Pasadena Audubon allege that the county failed to consider an adequate range of more environmentally friendly alternatives and failed to adequately analyze the Big Dig's impact that it will have on local traffic, water quality, wildlife, and air pollution. The Big Dig project is dealing with a number of issues regarding endangered species. Originally, the county told state and federal regulators that there had been no occurrences of any federally endangered species in the area during the past 2 years. However, information provided by Pasadena Audubon, which has been conducting weekly wildlife surveys in the Hahamongna Basin for many years, showed that within the past 2 years that there's been numerous occurrences of least Bell's vireo, as well as a recent occurrence of burrowing owl. These discoveries have delayed the Big Dig project as regulators attempt to provide adequate protection for these endangered species. The Big Dig project is expected to destroy nearly 70 acres of some of Southern California's most valuable wetlands and riparian habitat. Currently, there's two ongoing federal and state permitting processes under the Federal Clean Water Act as well as the Federal and State Endangered Species Act. Currently, under the Clean Water Act, the county is required to acquire what's called a Section 404 dredge and fill permit. The application for the dredge and fill permit has been held up, though, by the county's failure to demonstrate that the project is the least environmentally destructive practical alternative, as well as failure to identify mitigation wetlands for the project. No, they did not, which is what's held up the Federal Clean Water Act permitting process. The Federal Clean Water Act permitting process requires that a project applicant, in this case the county, do what's called a least environmentally destructive practical alternatives analysis, analyzing alternatives to the project and determining what would be the least amount of destruction to federally protected wetlands. In this instance, the county failed to do that alternatives analysis. However, nonetheless, the Army Corps of Engineers was prepared to issue this Section 404 Clean Water Act permit until the Arroyo Seco Foundation Pasadena Audubon Society pointed out that the project's application failed to present that exact alternatives analysis. The county's environmental mitigation plan is for a 1-to-1 ratio, replacing for every acre of wetland that will be destroyed by the Big Dig project will be replaced by another acre of wetland. However, this has proven problematic as most projects require 2-to-1 or 3-to-1 mitigation in order to alleviate the environmental impacts of this project. Right now, it is uncertain when the county will be able to obtain the permits necessary to be able to move forward with the project, given that the county has yet to provide important information to those agencies, including where the mitigation will occur, and as well as their analysis to the alternatives to the proposed project. The Arroyo Seco Foundation and Pasadena Audubon's position with regards to the sediment removal necessary at the dam was developed in this alternative that was proposed by the city of Pasadena using a panel of hydrogeological experts from a number of disciplines and universities, including Caltech. That panel concluded that a mere 1.1 million cubic yards of removal, rather than the county's currently proposed 2.4 million cubic yards, would be adequate to protect surrounding communities from floods, as well as reduce the environmental impacts and health impacts that this project will have on surrounding neighborhoods. This lawsuit has region-wide and statewide implications about flood management and river restoration. We believe that these streams should be utilized for multiple uses, including water storage, habitat restoration, and as well as to provide habitat for fish and other wildlife. Christina and I would like to thank the supporters of the Stop the Big Dig lawsuit. Due to your generous contributions, we've been able to secure many additional protections, including protections for Lee Spells Vireo from this project, as well as delay this project, and ultimately we hope to secure, and I'm optimistic about, securing a positive resolution for this project that adequately protects the Hahamongna Basin, its vital wildlife, and its invaluable wetlands and other biological resources.